We have with us Justice AP Shah, the man who was tasked by the government to go ahead and simplify the DNM report and also come out with some veracity whether it will be valid enough to go ahead and levy a penalty on RIL at all or not. Thank you so much for speaking to Bloomberg Quint, sir. In your report, you've mentioned that both RIL and ONGC were aware of the gas migrations, but both of them did not report it on time.
Just let me explain. See, ONGC made a number of allegations against RIL. For example, that RIL had their wells located near the boundary of the ONGC's block. The pipes were deliberately slanted, etc. So, committee has not gone into those allegations because it was simply not possible to give any finding either way. But there was a report commissioned by RIL and NICO in 2003. This report was also given by DNM. And that report clearly suggested that there is a possibility of connectivity between RIL's block and the blocks of ONGC. And it also predicted that on account of exploration in RIL's block, there might be depletion of gas in ONGC's block. Now, under the terms of the PSC, a contractor is duty bound to bring all material, all interpretations, all reports to the knowledge of the DGH. It has to be shared with DGH. That's the obligation created under the contract. For the reasons which are, difficult to comprehend, RIL had not shared this report with the DGH, and ONGC got hold of this report only during the course of the hearing. So this has to be investigated further. So, but this is a very significant aspect that there was a report which showed connectivity between possible connectivity between the different blocks. And if this was brought to the notice of this ought to have been brought to the notice of the DGH in 2005, not now, not 2009 or thereafter. But it was not, because 2005 RIL's IDP was approved by DGH. Now coming to ONGC wrote to the government, to the DGH, for the first time in 2013, saying that there is a possible connectivity between the two blocks, and there might be migration of gas, and that has to be investigated. And ONGC said that this they discovered on the basis of some G&G interpretations. Now the committee found that these interpretations, this material, this data was available to ONGC in 2007. So the question is, why ONGC waited from 2007 to 2013 for raising this issue of relating to connectivity? So this was really, I would say that this was rather negligent on the part of ONGC not to bring this to the notice of the DGH. All this situation of migration of gas could have been avoided if the ONGC had acted with some diligence.
Sir, it's evident that gas has migrated. This was not contended by neither ONGC nor by RIL. But what was always contended by RIL in particular is the valuation of the losses to the exchequer. Reason being that RIL is of the opinion that they have put in a considerable amount of capex, so they should be compensated for it first, and then also that they did not go ahead and indulge in any misconduct when they extracted the gas. How are you interpreting this argument?
See, leave aside the issue of knowledge. Let us proceed on the basis that the RIL had no knowledge about the connectivity or possible connectivity, and it explored its own field in good faith. the Committee on Interpretation of certain clauses of the PSA and the P&G rules came to the conclusion that RIL had no right to retain the benefit which it got in the context of or account of that migrated gas. This was a fortuitous event because the exploration was started in one block. The gas started migrating from the adjoining block to the RIL's block. Now this was never intended to be given to RIL. What was given to RIL was the right to explore the gas in its own field. Now, it is true that the contractor does not have any proprietary or possessory right over the gas till it is produced. So, to that extent, we agreed with Professor Dentith, whose report was produced before the committee by RIL. But we could not agree with Professor Dentith's position that regardless of source from which the gas comes, so long it is explored in its own area by Reliance, then it will not amount to unjust enrichment. So that argument is not accepted by the committee. The committee's view is that this fortuitous gain cannot be retained because this government holds this property in public trust, and if the contract never intended to give this particular right in the respect of the migrated gas, surely the RIL has no right to retain this. So RIL must return the benefit. Now the next issue would be, what is that benefit? I mean, naturally the first thing would be the D&M has quantified the gas migrated from ONGC's blocks to RIL's block. So market value of that particular gas, that should be the criteria for fixing the amount of restitution. It is a restitution. It is not a penalty. Please let me make it very clear. When a party gets something which is not intended to be given to it under the contract or under any law, then that is called unjust enrichment. So it was never intended to be given to RIL as a gift by the government of India. It got it fortuitously. The question is, was it a justifiable conduct? The RIL's position was that the government's policy is to explore the gas expeditiously. That is in national interest. So it has explored the gas. So it is whatever is extracted from their field cannot be questioned. That's which is not accepted by the committee. The committee's view is that this would amount to unjust enrichment, and the RIL must return the benefit to the government. Now, in principle, this is the position that whatever benefit is received by RIL must be given back to the government. RIL has some different arguments on that. For example, RIL said that it has incurred heavy cost for the extraction of gas, this capex and opex, etc. That's true, but the argument of the DGH and ONGC was that the RIL never spent on infrastructure for exploring a migrated gas. All this investment is for exploration of gas from its own area, not for migrated gas, and therefore this should not be deducted, etc. So this is one area where the committee was of the view that it is not in a position to really give any view on that, really whether operating costs should be permitted or all the costs should be permitted. That's for the government to decide. The government will now quantify if they decide to accept the report. It's for the government to. It's only a report. It is not an adjudication of any of the issues. So ultimately, it is for the government to take a call on this and decide what is the amount of the unjust enrichment which is received by RIL.
Sir, in your report you've mentioned that ONGC is not supposed to recover the losses. What is the
let me explain. It is ONGC which went to the court with a claim that it lost this gas from its area. It lost the opportunity of take economic benefit of this particular gas, which was in their block by reason of migration to RIL's block. So the ONGC's claim also before the committee was that the restitution should be to the ONGC because as a contractor, ONGC could have explored the gas and taken benefit of that. That benefit is lost, and therefore the ONGC must get the cost of that particular, the market value of that of the gas which was migrated. ONGC's claim, according to the committee, is not sustainable in law because the principle is that what is given to ONGC is the possession of the land. The natural gas which is underneath the surface continue to be the property of the government. It is always property of the government till it is actually explored, produced, and it is brought to the point of sale. That is what the Supreme Court has ruled in the previous case of RIL. So the ONGC has no right over this particular gas. It has no right, either possessory right or proprietary right. A contractor would get a right only when the gas is actually produced, and not till then it has no right. And therefore, the ONGC cannot make this claim. And the government, since government continues to be the owner is in possession, in the sense that in our country rule of capture doesn't apply. All natural minerals below the land belong to the government, though the land might belong to a private party. This rule of capture is recognized by some states in America, but most of the countries don't accept that. Now, we could get only a direct case on this in Professor Dentist's book, that where the court ruled that no, this migrated gas, the benefit of migrated gas cannot be retained by the contractor. So this was a slightly different case. Here the law in India is that the government holds this property in public trust and it is accountable to the people. If the government never intended to give this particular gas which was lying in ONGC's block to RIL, surely RIL cannot retain that benefit. So therefore, this principle of restitution of the benefit which is received by RIL in the process of the exploration of this migrated gas.
Sir, pardon me for being the devil's advocate, but the fact is that in your report you've mentioned that, and you've quoted from the DNM report, that the portion of the field in ONGC's possession might not have any gas at all now. So how would you expect?
No, that's a different aspect. I mean, see, what is contemplated by PSC and the rules is that if there is a continuity of reservoir in different blocks, then and the other block is either given to the contractor or a contractor has made an application for allotment of that block, then the other block cannot be developed, because if there is a continuity of reservoirs in different blocks, the only way to develop the gas field is a joint development by both parties, both the contractors. It's the only way. Now, this did not happen in this case because the IDP of RIL was submitted in 2005 and it was approved. It was originally submitted in 2004, amended IDP went. That was a stage at at that point of time, the question of joint development arose. But here it didn't happen. One party unilaterally produced the gas from its field. And as they say that, as RIL says that from whichever source it comes. So they produced that gas, which as per the D&M report, it migrated from ONGC's block to RIL block. So surely, I mean, if that benefit is received, then the question is now whether RIL can retain that benefit. And there the different principle would apply. The principle is of whether RIL is enriched. The question is whether it is a just enrichment or unjust enrichment. On the interpretation of the various clauses of the contract, the committee came to the conclusion that it would amount to unjust enrichment. It was never intended to be given to RIL. So this is how the committee has put it, and therefore committee has said that the government is entitled to restitution of this benefit which is received by RIL.
Sir, for the understanding of our viewers, what would amount to more criminality? Pardon me for using this word.
I must clarify that I don't think there is any criminality involved. At least I don't see there is any criminality in this. Of course, there are allegations against made by both the parties, ONGC and Reliance, against each other, that the other party had a prior knowledge, etc. We had decided not to give any final finding in respect of the final conclusion in respect of the prior knowledge. But the fact that the RIL had that report in its possession is a pointer that it had some knowledge about the connectivity, and this should have been brought to the notice of the DGH. This is a contractual obligation. It is also obligation under the rules. It's a statutory obligations. But I don't think there is any criminality is involved. And I must say that this is only a committee which decided the matter. Not decided. I'm using a wrong word. Which made a recommendation on the basis of the written submissions of the parties. At no stage evidence was laid, witnesses were cross-examined before the committee. So this is not adjudication. This is the advice to the government. And according to the committee, the advice to the government is that this is unjust enrichment, so the government is entitled to recover.
So how do you assess the DGH in its current role? Would you say that this is just one case which has got a lot of attention, but there may be other cases?
No, there may be other cases. There may be the successive governments have not really paid attention to this aspect about the ordinarily DGH is manned by a senior bureaucrat, and I'm not really sure about what is the staff or the number of professionals engaged by them to study the material given by the contractors, etc. Really, I'm not aware of that. But hopefully this government will take steps to really make the DGH a proactive regulator, because it should not. A regulation does not mean, a regulator's power does not mean that it creates hindrance in the exploration business, but it has to support wherever it is necessary. It has to promptly resolve the disputes if such disputes occur between the parties. So these are the issues which the government should address when it decides to improve the office of the DGH.
So one very strong view was that instead of having a bureaucrat, why not have a technocrat who would...
See, I'm not sure whether a technocrat alone would be able to act as a regulator, but there can be a multi-member body. You can have a technocrat and a bureaucrat, or some such body. I'm just giving saying something off the cuff. I'm not sure how this will work, but the presence of a technocrat in DGH is very essential. A reputed technocrat may be hired by the government on contract basis. I mean, some such. I mean, I don't know how this could be achieved, but just as a suggestion, I see some merit in what you say.
Sir, one power that you would definitely want the DGH to have, which it does not have right now, that can resolve such issues much faster and ensure that the possibility of companies withholding information goes down.
For the purpose of dealing with the issue of withholding the information, the government need to give more powers to the DGH. But for effective regulation, when I say effective regulation, I'm looking at a broader picture that the country needs more oil, more gas. So really, it's necessary to encourage private sector. It is necessary to see that there is more and more production in the country. But at the same time, the DGH must become more proactive in order to ensure that the disputes are taken note of at the very early stage. The issues are resolved. I mean, DGH would be regularly interacting with the parties in order to ensure that there is no hindrance in the production of these natural resources.
So, two last questions. The first one is, why was lateral drilling not focused on in your assessments?
See, these are, I will tell you, a considerable amount of time was spent by the ONGC Council on the issue of location of wells and the manner of drilling. I mean, and there is a equally effective answer given by RIL and the quoting the management committee's reports, etc. And really the committee lacked that kind of a technical expertise to say anything final on this issue. So for that, the inquiry must be made by the government. Committee had its own limitations. So whatever was the committee could, and wherever the committee has decided that wherever it is not in a position to give a prima facie opinion, because it's a prima facie opinion, is not in a position to give opinion, it will refrain from giving any opinion, because it will not be fair to the parties to have kind of any adverse finding against them without the committee being completely satisfied on how the issues to be answered.
Yes, sir. So one last question: will you be available if the government approaches you for for your expert guidance on such issues again?
Well, I'm not claiming I'm an expert. I'm an outsider. I don't know much about this field. I just, in the course of arguments, I learned something. But surely it's for the government. I cannot what kind of committee they want. It's for the government to decide. So the government asked me to do this take this task, do this. I have performed that. But beyond that, I can't say anything.
Yes, thank you so much for speaking.
Thank you.